Hello everyone, I'm Kyle Hackley, the immigration law firm of Hackley and Robertson, and I'm sitting here with my partner, Summer Robertson, managing partner, and also with colleague attorney Ryan Kazabungi. Just earlier today, we started our conference room series, and we invited people into our conference room to direct message us with any questions they may have regarding immigration law. And as it so happens, a question came up right away, and we thought, while we're together, let's go ahead and answer it. Summer, would you mind reading the question for us?
Sure. I'm from the UK. I'm looking at a particular business in the United States to purchase, but I want to be sure I can obtain the appropriate visa to run and operate my business before I close on the transaction. Is this possible?
Okay. I like that question because it comes up a lot. Ryan, real quickly, give us a rundown of what the requirements are for the E2 investment visa.
Certainly. The E2 investment visa is a visa that's available to, first off, nationals of a country with which the U.S. has a treaty of commerce and navigation. That list is easily findable on Department of State's website. But beyond that, the business itself must be a business that the foreign national makes a substantial investment into, that is more than marginal to support the investor and his family, and that's a real and operating business, and the investor's personal funds have been put at risk.
Okay, thanks for that. Now what I'm thinking with regard to the question asked, if I'm recalling it properly, I want to know if they're able to actually purchase this business knowing that they're going to have a visa in hand versus purchasing the business, not having a visa, and then what do they do with the business? And what I'm thinking is, pointing to what you said, is the money at risk. How can the money be at risk if in fact there is a contingency? Is that what you would call it, a contingency clause, that if the visa is not issued, that the person doesn't have to buy the business? That would be the first thought. What do you think about that? Is it
in this case, the answer is yes. In this instance, the Department of State will consider the investment funds in this instance at risk if that is the clause contained in the sale agreement. That will be recognized.
I agree with you on that. In fact, we have a case coming up similar to that, and we're going to recommend to the client. That is, the first question that came up. We welcome more. What we're talking about today is the E2 investment visa. There's a lot more to be found on our website at www.hackleyrobertson.com, and also look for more of our videos on Twitter and more on our feed. Thank you for joining us.